Many of the employees had either received all positive reviews or they hadn't received any evaluation yet. So let's dive into the details of this with federal employment attorney Dan Meyer. Dan also served in the Office of Inspector General at the U.S. Department of Defense under 3 different administrations with a focus on protecting whistleblowers. Dan, welcome to the show. So the judge said today that the Office of Personnel Management used a loophole to fire these workers. What was that loophole?
Well, the loophole is probationary employees come into two types. Those who can be terminated for events prior to when they were hired, those who can be terminated for events while they were hired. And that's the easy path, is firing an employee for events, conduct, or performance while they were an employee. All you have to do is give them written notice. The problem is you have to have proof of what they did, and that's what offended this judge, and I think he was deeply offended. He's calling the government attorneys liars, which, is kind of scary language coming to a judge who has, criminal contempt powers to exercise against attorneys. Yeah. So the loophole needed justification, and the justification wasn't there.
The judge did make a point, though, to say that there is a legal way to get these firings done. And he even said that some of those reduction in force orders that are being issued right now today may be legal. So explain to us the difference, why some are legal and some aren't. Is it all just about making that proof there as to why?
Well, the road to hell is paved in due process. It's what judges deal in. It's the rules need to be followed. The judges don't really focus on outcomes all that much. We've been here before. PATCO, 1980, Ronald Reagan sacked the air traffic controllers. Postal Service downsizing for the next decade. And then the Clinton administration, the Department of Interior, had huge rifts. So reduction in force, that's understood. The president has the power to shrink the executive branch, but he has to do so in an organized way that allows the preferences that exist under the law to be abided by. So if it comes to a RIF, if you've been on the job maybe 5 years and you're not a veteran, you may go, and the veteran who's been there 6 years and served in Southwest Asia may stay. So the RIF process is very complicated, very procedure-oriented, and RIF litigation goes on and on and on. When I started in this area of law in 2000, I was handling cases from the Forest Service downsizing in 1993.
Wow. Wow. The judge here ordered that the agencies to immediately reinstate these thousands of employees. He even gave them just a week to report back on how they've complied for each and every employee. But what if they just don't do it? The Trump administration was actually supposed to come and testify in court yesterday to explain to the judge the process they were using for these firings. But yesterday, the government just made it clear they weren't going to comply with that order. They weren't going to appear. So what if they just refuse to reinstate these employees as they've been ordered to do?
Well, then we have conflict between the judicial branch under Article 3 of the Constitution and the presidency under Article 2 of the Constitution. So the judge could cite the lesser officials for criminal contempt. He could order a hearing. The problem is the prosecutor comes from the executive branch and isn't from the Department of Justice. And the U.S. Marshals that are the administrators and would have to serve the warrants and the writs of mandamus also are from the executive branch. So this could be a battle because judges don't have a lot of resources. It's a very economically run, efficient branch. It deals in decisions, not in sort of agency outputs. And it relies on the executive branch for a lot of its actions. And the president could simply tell the prosecutors not to prosecute and tell the federal marshals just to sit on their hands. And then we have a double crisis. But, criminal contempt, there's under Rule 42, criminal contempt doesn't have limitations on the penalty. If you get the lighter criminal contempt, it's a $1,000 fine and a year in jail. But if you're a senior official in the federal government, you end up with a felony charge, you have to resign. So the judges could end up taking out all the people that Donald Trump is now putting in as leadership in some of these agencies.
That would be quite the battle there. So much years of experience with you, Dan Meyer. Thanks so much for your expertise here.